All right, the next case to come before the court for argument is West Bay Care and Rehabilitation Center versus Estate of Carl May et al. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you do plan to reserve time, please let me know when you come to the podium so I can keep track of the time and keep you apprised if you're getting close. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podiums. The only other thing I will address right now before we begin are with regard to appellees. Have you made a decision how you're going to split your time?
Yes, Your Honor.
Okay, I'll just leave that up to you then. All right, we've read your briefs and are ready to proceed when you are.
May it please the court, Your Honors, my name is Brent English. I represent the appellants in this case, which raises some very interesting questions. I was not counsel for the appellants at the trial level. So as a result, it's taken me quite a while to dig through what is a pretty extensive record to ascertain what I think the relevant legal issues are. So on behalf of the appellants, I would respectfully submit that the trial court clearly erred in granting a summary judgment for both West Bay as well as the estate of Carl May with respect to the claim of a fraudulent conveyance. Ultimately, although there was a lot of documents filed and a lot of pleadings that were made and lots of proceedings that occurred, ultimately the trial court relied upon a contention that I believe is fundamentally erroneous, that the doctrine of collateral estoppel bars the appellants from challenging the claim that there was a fraudulent conveyance in this case. So it's important to look at what the facts are with respect to that claim. In 2010, there was a lawsuit filed against Doris Ney, who has since passed away, in the I think it was the Rocky River Municipal Court, seeking a claim of about $5,000 for unpaid nursing home services to a non-party in this case. And one of the claims that was made by the plaintiff in that case, that is not a plaintiff or in any way related to this case, was that there had been a fraudulent conveyance by Doris Ney of assets that allegedly belonged to Carl May, her husband. That claim was never adjudicated, and indeed, there was ultimately a judgment that was rendered for a monetary amount of $5,000 approximately, and that judgment was paid. There was no determination, no adjudication, and no litigation, so far as the record is clear, with respect to whether or not there had ever been a fraudulent conveyance. Conceitedly, there was a claim made by the plaintiff in that case that there had been a fraudulent conveyance of certain real property, which is at issue in this case. However, I believe that the law is pretty clear, and we have briefed this matter extensively in our brief, that unless that determination was made by the trial court in that other case and that there was a full opportunity to litigate that claim in the other case, that the doctrine of collateral estoppel does not apply in this case. And the reason is that the doctrine of collateral estoppel requires that there be an opportunity, a meaningful opportunity to actually adjudicate a claim. And the case law is pretty clear that unless that claim is actually adjudicated and unless the court makes specific findings, that is not binding upon any subsequent court. The trial court in this case erroneously determined that the doctrine of collateral estoppel applied. This was a position that was advanced very late on in the litigation by both the guardian the administrator of the estate of Carl May, as well as West Bay. I believe respectfully that is wrong as a matter of law. It's wrong as a matter of fact, and there is not any evidence in this record that would suggest a aside from collateral estoppel, that a fraudulent conveyance was ever made by Doris Nay.
Counsel, excuse me 1 minute, and I
Yes.
apologize, this is my fault. Did you reserve time for the vote?
I would like to reserve 3 minutes, and thank you very much, Your Honor,
Thank you.
for reminding me. So with respect to our first assignment of error, we contend that the trial court simply got it wrong with respect to fraudulent conveyancing, and thus the rest of the claims in this case should fail. Now, interestingly, the trial court never entered a money judgment for the plaintiff in this lawsuit. The plaintiff is West Bay Care and Rehabilitation Center. They sued a variety of people claiming that they were obligated to pay approximately $135,000 for nursing home care for Carl Day, but in fact the court never entered a judgment for any amount of money. We raised that in our assignment of error number 2, and in response to that, the appellees have contended that, well, you really don't need a money judgment in order to make a finding of a fraudulent conveyance. I would respectfully disagree, at least with respect to the plaintiff in this case, because the plaintiff has no claim whatsoever if, in fact, it does not have a money judgment. A fraudulent conveyance is a remedy. It is not a goal in and of itself. And there is no standing for West Bay to contend that there was a fraudulent conveyance ever made absent a judgment for an amount of money. Now, interestingly, in this case, there's been an intervening case decided by the Supreme Court of Ohio called Embassy Healthcare versus Bell. And it does appear, and in that case, the Supreme Court of Ohio held that it was required that there be a claim made against the estate of a decedent within 6 months, or else that claim was entirely barred. West Bay concedes that it did not make a claim against any party in this case within 6 months of the death of Doris Nay and within 6 months of the death of Carl Nay. And as a result, I would respectfully submit that that intervening authority, which was decided on December 12th of 2018, should bar West Bay's claim in any event. But interestingly,
Would that include substituting the estate in place of the actual person?
I'm sorry.
Would that include substituting the estate in place of?
I believe that that is a fair reading of the Embassy Healthcare case. In any event, since there is no money judgment with respect to the plaintiff, I would respectfully submit that the trial court clearly erred to the extent that it granted a summary judgment in favor of West Bay on the fraudulent conveyancing issue. Now, I thought carefully about the argument that's been advanced by the estate of Carl May that it has a separate independent claim for a fraudulent conveyance, and I believe that it potentially does. But the problem with that claim is that under the circumstances of this case, and given the record that exists in this case, and given the fact that collateral estoppel clearly does not apply in this case, the estate of Carl May was not entitled to summary judgment either. So as a result, neither of these judgments is valid. And the judgment as to West Bay is not even a judgment at all because there's no final appealable order. And the judgment as to the estate of Carl May, while potentially final and appealable, is invalid because the summary judgment is incorrect as a matter of law. If collateral estoppel does not apply, the record evidence in this case does not establish that there is not a genuine issue of material fact in dispute, or that the estate of Carl May is entitled to a judgment as a matter of law. The remainder of our assignments of error flow from that. So in this case, the court determined that it was going to award both pre-judgment as well as post-judgment interest to both West Bay and the estate of Carl May, even though there is no money judgment. I submit that under the law, that is completely irrational. I agree that if there is a finding of punitive damages and a finding of attorney's fees can follow, but there is no determination in this record that any conduct was undertaken that gives rise to a finding of punitive damages. There is no award for punitive damages. Thus, the idea that you get pre-judgment interest in a case such as this, I believe, is fundamentally mistaken. With respect to post-judgment interest, while, of course, there is a statute, and there's certainly a statutory right to post-judgment interest, there has to actually be a monetary judgment in order for post-judgment interest to apply. And in this case, as I pointed out repeatedly now, for sake of, I just keep saying it because it's true, that there's no basis then to grant either pre-judgment or post-judgment interest. Another claim that exists in this case is that Mr. Anderson, in his capacity as the administrator of the estate of Carl May, was also appointed as a receiver for one of the properties. The statute expressly says, the statute authorizing the appointment of a receiver expressly says that that is impermissible. That if you have an interest in the outcome of the case, you may not serve as a receiver. His only response to that is that no one raised this issue at the time it was made. Well, I don't think that that is something that is subject to waiver. If the statute says you shall not be a receiver, then you shall not be a receiver. And this court should have no difficulty whatsoever in determining that that is clearly error as a matter of law. Lastly, with respect to our assignment of error involving appellant Michael Bray. Michael Bray asserted a claim in this case for unjust enrichment. He asked for a declaratory judgment that his contributions to maintaining these properties over an extended period of time should be given some equitable consideration by the trial court. And whether or not that is ultimately established to be a valid claim or not, irrespective of what the evidence shows, and there is no evidence in the record at this point with respect to that matter, the court erred in simply dismissing this counterclaim. I would respectfully submit that a court may not sua sponte dismiss someone's claim without at least a 12b6 motion having been filed or a motion for summary judgment having been filed. It is clear that Michael Bray has at least an equitable claim, and I would respectfully submit an equitable interest in these properties in any event, and for the trial court to simply dismiss those claims sua sponte, which is what occurred in this case, I submit is clearly error. We cited a number of cases in our brief that say exactly that, and that's precisely what happened in this case. So as a result, in summary, Your Honors, I believe respectfully that the trial court erred in finding that collateral estoppel applied. The prior proceeding was not decided on the grounds of a fraudulent conveyance. There's no evidence in the record that would suggest that. And as a result, that should not be preclusive of my client's ability to contest the allegation that there was a fraudulent conveyance, that in this case the court basically leapfrogged over all the requirements that the fraudulent conveyancing statute requires and simply said you are bound by a prior decision that did not relate to fraudulent conveyancing. People make claims all...
We need a rebuttal time, just so you know.
Okay. Well, people make claims all day long in lawsuits. In this case, in the underlying lawsuit, there was a breach of contract, there was a claim of unjust enrichment, and then there was a claim of an alleged fraudulent conveyance. The court basically decided that on a default judgment and made no findings whatsoever that are in this record that there was ever a fraudulent conveyance. Thus, collateral estoppel should not, as a matter of law, apply. I'll reserve the remainder of my time. Thank you.
Good morning, Your Honors. My name is Kurt Anderson. I am the administrator of the estate of Carl May. I represent the estate of Carl May. Previously, the guardianship estate, and now, unfortunately, because Mr. May has passed away, I am actually administrator of the probate estate. I will be splitting the time, 10 minutes for myself and 5 minutes for West Bay. I am keeping track of time, so when my timer goes off, I'll try to be prompt and sit down. Very quickly, Mr. English is just simply wrong when he says that there was no litigation of the fraudulent conveyance claim in the Center Ridge action. That was the entire purpose, the only issue on which Center Ridge filed for summary judgment. And it's important to note that Center Ridge did not obtain a default judgment against David Bray. They did file a motion for default judgment, but that motion was then held in abeyance. Center Ridge proceeded to file a motion for summary judgment, bearing in mind also that Doris May had filed an answer in which she admitted that these properties were transferred when they were transferred, and that they were transferred for no consideration. In response to Center Ridge's motion for summary judgment, which was the exact same properties, the exact same transfers, the exact same parties from whom and to whom the parcels were transferred, and for the exact same purpose, which was to avoid payment to a medical provider for care given to Carl May. And the only way that Center Ridge could have obtained a judgment of any kind against Doris May was to find that she had assets of Carl May, because the contract that she signed said she was not personally liable out of her own assets. And the only assets out of which Center Ridge would require to be paid were the assets to which she had legal access, that were in her possession and control, and that she lawfully had access to. When Center Ridge filed for summary judgment, it was specifically on that issue, that you did have assets that belonged to Carl May, and that should rightfully be considered assets of Carl May, and against which, or from which, Center Ridge deserved to be paid. That was the only issue on summary judgment. For whatever reason, neither Doris May or David Bray filed any opposition to that. The fact that there was no opposition filed doesn't mean that it was not actually litigated. The cases are very clear that when there's an opportunity to respond, the motion has been made, there's an opportunity to respond, they could have if they wanted to, they didn't. The court also is obligated by Civil Rule 56 to make its own independent analysis of the facts that are before it, and to only award summary judgment if in fact those facts show that there is no genuine issue of material fact, which the court agreed. Yes, there's no issue of material fact. Now, it didn't spell out in explicit words, the court finds that there has been a fraudulent transfer, but that is the only way that the court could have then proceeded to award a monetary judgment, which it did do. And in fact, in this case, which is being decided by the very same judge who made the ruling in Center Ridge, he explicitly said the issue of fraudulent transfers of real estate to avoid payment to a medical provider for the care of Carl May was litigated and essential to the judgment awarded. This is the very same judge who made that decision. The record speaks for itself, but who better to say from that record than the very judge who made the same rulings in both cases?
What of that other that prior case to Center Ridge, what part of that record is in this record?
That was filed along with our motion for summary judgment. There's a certified copy
Of the judgment entry?
of the pleadings, the motion for summary judgment, the documents that Center Ridge submitted in support of that, the judge's order. There are a couple of pieces that I believe may be missing from that record, including the answer that was filed by Doris May. But that answer isn't relevant to what subsequently happened, which is the motion for summary judgment. And the court's own order says that the defendants didn't file a response, so there would not be one in the record. But all of the supporting documentation and the basis for the judge's ruling is in the record in this case, on top of which...
The basis for the judge's prior ruling is shown in this record by him saying that in this case.
No. He's looking back and saying, yes, the reason why I granted summary judgment in that case was because there was no genuine issue of material fact as to the fraudulent transfer. The judge is saying in this case that the reason for the grant of summary judgment in that case was the fraudulent transfer. But he said, it's implicit in that finding. I didn't say it, but it's implicit. You can't get from A to C without finding B. And the court found, in fact, that that was true, that there had been a fraudulent transfer. And so when the judge was asked in this case, hey, look, this has been litigated already, he agreed, yes, it has been. There wasn't a specific statement of a finding, but the rationale, it was the only argument that was raised, it was the only rationale that could plausibly support the grant of summary judgment to Center Ridge. Once having been in court, having litigated the exact same issue, Doris Ney and David Bray are barred from relitigating that and trying to get a different result in this case. And there really hasn't been any argument that the rule is what the rule is. The only argument that was raised in opposition to summary judgment in this case was that the court hadn't made an explicit finding in the Center Ridge case of a fraudulent transfer. But when you look at the record of Center Ridge, you can't come to any other conclusion except that that is the reason why. Very quickly, I want to touch on the questions of the fully litigated. I already mentioned that in fact there was no default judgment. It was and there was an opportunity, and the fact that they chose not to doesn't mean that it was not fully litigated. This question of a monetary judgment, the Fraudulent Conveyance or the Fraudulent Transfer Act defines a creditor as someone who has a claim, regardless of whether, and this is explicit in the definitions in the statute, and we briefed this, regardless of whether or not that claim has been reduced to judgment. So there is a claim, and you do have standing. That's really West Bay's argument, it's not mine. It's our property. We don't need a monetary judgment, it's our property. Now, true, if in fact the court rules that, for whatever reason Judge Moraldi was wrong, that collateral estoppel would return everything back to the trial court. But the fact that there was no monetary judgment is not an independent bar to the estate of Carl May recovering those assets. The question of the attorney's fees, a fraudulent conveyance is by definition fraudulent. And the court agreed that the specific purpose for doing this was to avoid payment to a medical provider. There was a specific purpose to injure someone. So the malice that is arguably required, we would say it's not even required by the law because the statute does not apply in this case. This is not an equitable tort action, this is a statutory remedy action. Be that as it may, there was enough evidence in the record, the record shows that the purpose that this was done was to avoid payment to a medical provider, which is an intent to injure, which would support attorney's fees. The appointment of myself as a receiver, it was done by agreement of the counsel. Mr. English was not counsel at the time. Unfortunately, it wasn't recorded in one of the judge's pretrial orders, but it was specifically noted in the entry that absent any objection from the parties, and they could change their mind at any point in time. There's never been any action taken in the receivership, so there's been no harm, no damage, no prejudice. They still have their opportunity to object. The court continues to have continuing jurisdiction over the receivership, so they could object at any point in time. It's not an issue that is ripe for decision by this court. If they have an issue with it, you can take it up with Judge Moraldi. The order provides for that. And then finally, the issue of the counterclaims, that absolutely was litigated.
Go ahead.
All right, just real quick. On that issue, the fact that those counterclaims were technically still pending was raised by the defendants in their opposition to our motion to dismiss. We chose to dismiss our remaining claims because we wanted to get this very issue to the Court of Appeals as quickly as we could. They objected and said, oh, wait a second, we've got those counterclaims. But the fact of the matter is that those counterclaims hinged on a claim of ownership. And because the court had already decided the issue of ownership. It had disposed of that fundamental issue. And the court essentially issued an order in supplement of its motion for its summary judgment order, agreeing that those claims were also disposed of and were now moved. So it was not a sua sponte, out of the blue, unbriefed issue. They raised it, we briefed it, we had full argument about it. The judge says, no, those claims are moved. It was not sua sponte. And there's no reason that those claims should remain or drag this case back to the trial court simply for a ruling on those. The real issue here is whether or not there's collateral estoppel. And we would say that was fully litigated. All the facts, all the issues, there was an opportunity to litigate it, and that should remain as it stands. I'll give the rest of my time to Wes Beck.
Good morning, Your Honors. In the interest of time, what do I have left? About 2 minutes?
3 minutes and 19, 18, 17.
Okay, thank you. I am Kyle Silvers. I represent West Bay Center. With me is my co-counsel, Michael Nathan. I would just note for the record that we concur with every argument that Mr. Anderson has made, and in the court's indulgence and patience, I just want to make a few quick observations. One, there has been representation to the court that there was no monetary judgment. That is incorrect. In the lower court, the trial court's November 1st, 2017 judgment entry, the court specifically stated it's also undisputed that a judgment in favor of West Bay in the amount of $136,764.66 was entered on March 7th, 2017. That's document 168 in the record. Also at that time, the court found that pre- and post-judgment interest were appropriate in this amount in light of the fraudulent conveyance and bad faith that had been shown. We believe and have argued before the court and in our brief, so I don't want to take up the court's time this morning, the award of attorney's fees was proper. Because this is a fraudulent conveyance case, I would respectfully direct the court's attention to Local France U.S. Corp., the interstate, which we have briefed, which finds that in light of fraud and bad faith, attorney's fees are enforceable. While Ohio has adhered to the American rule, there are exceptions. Certain laws have been enacted in order to codify the court's historic authority to award litigation expenses, which include attorney's fees, when there is egregious conduct, which we believe has been the case in this lengthy and protracted litigation. Do I have time?
You do.
Oh, I do, okay. That's a first. All right. As Mr. Anderson has argued, we believe pre- and post-judgment interest apply. I would argue post-judgment interest is moot. That's a given in these cases. Pre-judgment interest, we believe, is appropriate given the ongoing issues in this case, the fact that there was a judgment entered, and the fact that that argument has been reiterated several times. So again, I would direct the court's attention to the remedies set forth in Revised Code 133610 and 133611, that they are not a sufficient deterrent to discourage applicants and other debtors from making fraudulent conveyances, which is why attorney's fees are typically awarded in these types of cases. Thank you for your time.
Thank you.
Those are all interesting arguments. Let me just point out to the court what the actual judgment entry in the underlying Center Ridge litigation said. Judgment is granted in the amount of $5,300 and some in favor of certain parties and against certain parties. That's what it says. Mr. Anderson would like to believe and wants this court to conclude that that was a determination made on the basis of a fraudulent conveyance. Courts speak through their journal entries. They don't speak through seances. They don't speak through presumptions. They don't speak in any other way other than in a judgment entry. If the court had said, I find that this had been a fraudulent conveyance and et cetera, then I would not have an argument here with respect to collateral estoppel. However, the court made no such finding, and it is impermissible for any court, and certainly any litigant, to contend otherwise if in fact the judgment entry says what it says. To answer your question, Judge Hensel, the record in this case includes a complaint filed by Center Ridge. It does not include the answer filed by Doris Ney. I don't know why. David Ney never filed an answer. He didn't do anything in respect to the case at all. He is the alleged transferee of these allegedly fraudulently conveyance properties. There is a motion for summary judgment, and there are claims in the complaint that allege a breach of contract, a claim on an account, a claim for unjust enrichment, and a claim for a fraudulent conveyance. Now, I don't know what the judge relied upon in reaching his conclusion that $5,300 was owed to Center Ridge, and neither does the plaintiff and the estate of Carl Ney in this case, and neither does this court based upon the record that it has. So the fact that the court in this case said, look, I really intended to make a finding of a
Your
fraud.
last time.
Okay,
Thank you, sir.
okay, thank you very much.
All right, thank all of you for your presentations. The court will take the matter under advisement, issue a written decision in due course, which will be mailed to all sides, posted on our website and on the Ohio Supreme Court website.